All right, guys, it's the Search and Seizure show. It is October 15, 2024. I am here with my very good friend and co-instructor, Zach Miller. How are you doing, my friend?
Doing well. Good to see you. Great show tonight on
Uh,
Leosa.
so tonight we talked about LEOSA, the Law Enforcement Officer Safety Act, otherwise known as HR 218, which allows police officers to carry concealed in all 50 states in Colombia, Puerto Rico, and Guam. Are you qualified under HR 218, or you need to do that?
I am. Yep.
You just go to your local department and they call
Yep.
you?
They handle it all. Yep. We do. We have a bunch of retirees here from out of state, and we do it for them as well. No cost.
Yep. All right. Do me a favor, Josh. Do me a favor. It's easier for you to email me first because I'm in the middle of this, and it's just easier for me just to be reach out to me, and I will we'll go from there. Okay, there's my email. Okay, so first of all, do do so somebody says so we're talking about Leosa. Do 15 to 17 round Glock magazines have restrictions? Yes, I do believe you're not allowed to carry a high cap mag. Colorado is 15 rounds. California is 10 rounds. New York is probably 1 round. I don't think you can carry a high cap mag under LEOSA. Okay, LEOSA says nothing about magazines. It defines a firearm as a device that can expel a bullet with explosion. Right. So I don't think it includes magazines. Under the Second Amendment, I think you have a good argument, but you're not looking to go to the Supreme Court on a magazine case and so forth. Um, and Anthony is also in the ATF has ruled LEOSA does not cover magazines. Anthony, do you have that for me? Is there any way, do you have that they can send that to me or no? Man, let me give you my email because I did not know that. And that's actually good. It helps confirm that I'm teaching the right thing around here. So Cordell says CCW insurance. I have here I have U.S. Law Shield. Let's see. Oops. So I have U.S. Shield, U.S. Law Shield. But that is I'm not sure. I don't have a recommendation. I'm not endorsed by them. I have to pay, full retail for this. The problem that I have with my insurance is that because I'm in Washington State, it has to be real insurance. Um, Washington does not allow just general self-protection coverage. It has to be like legit insurance. Most states don't require that. So if it wasn't for that fact, maybe I would shop more. There's only like two companies I can even get insurance from. Uh, do you have you don't have self-defense insurance, do you?
Nope, I don't. No.
All right. All right, let's look at some. If anybody has a question, just ask. Yeah, but it doesn't work for Washington. And it's because Washington has a law that you cannot insure illegal activities. So you can't. So they look at this regular like coverage as that kind of mentality, unless it's real insurance. Anyway, it's all bullshit. Okay. Here is all right. So let me. I haven't read any of these yet. Let me just kind of glance real quick. Okay. Let's see what this is. So look, this is a Nevada specific question, but I can answer it. Um, so this officer is from Henderson, Nevada. He says domestic battery reported outside the 24 hours, but within 7 days. In Nevada, can police officers make a probable cause arrest for domestic battery if the incident is reported more than 24 hours, but less than 7 days? Okay, so you're like, what are you talking about, right, Zach?
Yeah.
Yeah. So
Is this for a
Nevada
warrantless
has,
arrest?
yeah, for warrantless arrest.
Okay.
So Nevada has a weird rule here. So if this is weird. I'm bringing it up because maybe it's interesting to some people for, to see how other states can handle DVs. So if an officer shows up to the scene to a domestic and the suspect is on scene, husband, wife, whoever the primary aggressor is, the misdemeanor battery has to have occurred within the last 24 hours. if it occurred 25 hours prior and the suspect is on scene, the arrest cannot be made for the misdemeanor committed outside the officer's presence.
Wow.
Now it gets more confusing. If the officer arrives on scene and the suspect is not on scene, they have not had a face-to-face encounter, is what the law says, right?
Okay.
Then the misdemeanor must have occurred within this last 7 days. That means that the officer has up to 7 days from the time of the DV to go
Hmm.
find that person. And if you think about it, that part kind of makes sense only because it's trying to allow officers to arrest people who abscond before the police arrive. So that was happening the old 24-hour rule. If it happened, the 24-hour rule has been around in Nevada for years. And
Hmm.
basically, you show up on scene, you say, "Hey, did a domestic occur today?" Yep. Occur? Yep. When did it occur? 2 hours ago. You're under arrest. If it occurred 25 hours ago, or 3 days ago, you're not under arrest. Got to go apply for a warrant. Or really, what they do in those cases, they just give it to the DA's office and they'll do their thing. But that's what the officer is asking. So the answer to the question is always, when it comes to Nevada law here, when you arrive at the domestic, ask yourself this: is the suspect on scene? If the answer is yes, 24 hours. If the answer is no, you got 7 days from the time of the incident. All right. Pretty weird, right?
Yeah, that's interesting. That first one I've heard like that.
Now here's another officer from Henderson PD, but a different officer. Okay. When to do a pat down. So we recently had a district attorney mention that a pat down of a subject must be done immediately. And if officers wait to pat down, then it would be considered a violation of the suspect's rights. My question is, if the pat down isn't done upon contact, but as the investigation advances, the suspect is uncooperative and appears nervous, and then the officer is asked to do a pat down, but he refuses, can we still articulate patting the suspect down for weapons, or would it be a violation considering that he refused and wasn't immediately done? Look, it's not the best synopsis of what the officer. I know what the officer's asking, but let's just
Mhm.
go with this. Okay, the first thing, Zach, is does the pat down have to be done immediately? Is there like a timer on this? Once you
No,
build reasonable suspicion for armed and dangerous.
no, there isn't. No. But the longer you wait, I mean, the less. So this is where subjective intent comes in. I've
Yeah,
seen some cases where the judge says, "Well, this particular officer apparently didn't fear for his safety because
yeah.
he waited so long, therefore it was an unlawful pat down." But we're not supposed to be taking subjective intent into
Yeah.
consideration.
Well, they'll almost like make it seem like it's objective too. Since the officer waited so long to do a pat down, that belies their reasonable fear for
Yeah,
safety. Yeah, it's still subjective, but it's whatever.
yeah,
So it's a credibility issue, Zach.
yeah. Well, yeah. I think so. But your RS can develop later during the interaction. Is he asking if we don't have RS at the begin to pat him down at the beginning of the interaction, and then things develop?
Yeah, look,
The
obviously
officer
he
a
says,
chance to
if you
pat him
don't if you
down?
don't pat him down initially, well, look, if you don't have reason to pat him down initially, then you wouldn't do it anyway.
Sure.
If you
Right.
pull me over for speeding and I'm 10 and 2, no sir, yes sir kind of guy. But
Hmm.
then after you start giving me a ticket, I'm like, F you, you're violating my rights. And I get out of the car, I'm like, what are you doing? This is ridiculous.
Yeah.
Um, it's not like I have a high cap mag in California like real criminals. And so, if I'm not like that guy, I mean, if I turn into that guy, like, I start turning green, well,
Hmm.
then certainly you can start patting me down. Maybe,
Yeah.
maybe you do wait for a backup unit to get this guy cuffed
Right.
and so forth. So I don't want cops thinking that they have to do it immediately. Just use good common sense. But like Zach says, it may affect your credibility that maybe you weren't reasonably in fear of your safety, I guess. Um,
Yeah.
Now, the other thing is, let me ask you this. This comes up every once in a while in our classes, right? Cops say, well, if I can pat somebody down, should I also ask if I have their consent to pat them down? If they say no, just pat them down anyway. Oh, what do you think about that issue?
I'm always a proponent of asking for consent, even if you have probable cause or in this case, reasonable suspicion, as an alternative to an alternative justification. Because if they say yes, I consent, then now I have consent as a valid basis for patting him down in this case. And I have reasonable suspicion to believe he's armed and dangerous. And if later on, and here's where it comes into play, I find something there to pat down he's not allowed to have, and now we're litigating this in a motion to suppress. We have two justifications for the pat down, and the defense has to defeat both of those to have the evidence suppressed. We only have
Correct.
to win one of them. So I'm a proponent of asking for consent, even if you know you have the authority to do it.
I am too. Now, the only thing again, it goes back to credibility, right? I have seen this argument and from especially well, my prosecutors tell me they don't like the whole if you really did legitimately fear for your safety, why are you asking them permission to be safe, However, I do like cooperation because the other thing is it could actually be a de-escalation tool, right, Zach? I
Yeah.
mean, putting hands on people without their permission versus just, asking their permission and, but if they say no, that might be another reason why they probably are armed and dangerous, because they're not, maybe allowing it. But the point
Yeah.
is you just confront it in court, but it should be okay. Now, this officer says basically it's a little statutory base in California. You know what a 5150 is? Or
Is that the mental health?
mhm.
Yeah.
And they're saying like a 5150 for civil commitment in Cali. Um, they saw this case called Scott v. Smith and involving Las Vegas Metro. It's basically using force on a guy that was a mental crisis.
Mm-hmm.
I don't have all the facts of this case, but I think the question comes down to is, you know, this is not quite the question, but I want to make it the question because I think it's helpful for people in the audience. Can you use force on people that are going through a mental crisis and they are subject to a mental hold, a civil commitment, I should say?
I mean, I know there, yeah, yes. I mean, under the Fourth Amendment, you can, I mean, the objective reasonableness. There's a Sixth Circuit case from several years ago that talks about, we have the typical Graham factors in a criminal use of force, or investigative use of force. But
Yeah,
they had their own additional factors they came up with in the Sixth Circuit when it comes to
yeah.
taking somebody into custody for pure civil mental health treatment. And
De-escalation, maybe.
yeah, yes. Whether
Mhm.
there's a judicially issued order, whether it's a
Mhm.
warrantless or all,
Yep.
or, you know,
Is the juice worth the squeeze? I think
yeah.
they said, and I forget how they put it, but it's like, are you going to cause more harm by
Hmm.
by using force on him?
Right.
It's like shooting a guy with a gun to his head. You know what I mean?
Yeah,
It's like,
right.
God damn. It's like,
Yeah.
okay, man, maybe just let him do it himself then.
Yeah. Yeah. Yeah.
Yeah. I mean, I've seen that case. There was one out of New Mexico where they shot the guy with a gun to his head. It was many, many years ago, but even back then, I was like, dude, I would, why? It did not look good. It did not look, you execute the
Oh,
guy for attempting to execute himself, basically.
yeah.
So
You
they're,
just facilitated it.
yeah, you facilitated it. Like, why don't
Yeah.
you like get a coat hanger and like pull the trigger on his gun? Get
Right.
like get like a fishing rod.
Yeah, right. Here, let me help you out with that. Yeah.
Why don't you help him out?
You seem a little hesitant.
Yeah. Hey, why? Hey, we got lunchtime soon.
Right. Right.
Yeah, no, it looked kind of bad. So I think he's also talking about like the people that like fight cops during these civil, like they try to do a 5150, they fight cops, and that's a crime, right? But
Hmm.
then they don't. Then it's the word like, and then the courts are looking at whether or not the use of force. He's like, I think what he's trying to say here is why not just charge him with a crime? Like, why do we have to look at even these Sixth Circuit factors, for example? Why not just if you're fighting me and you're resisting, then I'll just arrest
Yeah.
you.
Right.
However, I think can I say true, but when you're dealing with a 5150 or a civil commitment, you're not trying to arrest them. You're trying to get rid of them, and you're not trying to put them in jail. You're trying to put them in a mental facility where they maybe can get real help. You know what I mean?
Yeah. Yeah. They're not going to get it at the jail.
Oh, Doug, can you come on and ask that question because it's a really good question? Can I just turn on your mic? I love that question, by the way, and I want Zach to talk about this. So, can I just turn on your mic? No camera, just mic. All right, awesome. And Ryan, can you come up next? What's up, Doug?
Hey, how's it going, sir?
Hey, good buddy. Where are you from, by the way?
So I'm actually with Arizona Department of Public Safety.
Nice. You're a trooper. You're my kin. You're my you're You're my kinfolk because I was a trooper in Vegas.
Yes, I've taken a few of your classes back when I was a detention officer with Maricopa County Sheriff's Office. So
Dude, where was the class at?
it was in Phoenix. I took let's see, I took a couple of them actually. Search and Seizure was the one I remember the most.
Yeah, so just real quick. Sunrise Surprise, Arizona, or was it in Maricopa?
It was in Maricopa. It was or no, I'm
Okay.
sorry. It was at the Sheriff's Office training in Phoenix.
Yeah, Maricopa. Cool. Small world stuff, man. What you got, brother?
So I have a question. This has come up with a few different troopers. If I'm conducting, let's say, just a civil traffic stop for speeding,
Yep.
no indication of criminal activity, but the driver has a firearm in the vehicle, which in Arizona is perfectly legal. Um, I always take those firearms during the traffic stop. Um, if it's, let's say it's in a holster in the glove box, they say, okay, it's in the glove box. I tell them, all right, I'm going to hold on to it for the duration of this stop. If I walk back to my vehicle and take that firearm out of the holster to run the serial number, is that considered a search by taking it out of the holster?
Okay, what you got, Zach? Why don't you take a stab at this?
Yeah, I mean, yeah, I think either under either definition of a search, Jones or Katz, it's a search. I mean, you're physically intruding upon it by removing it out of the holster, and there's an expect. I imagine you have a reasonable expectation of privacy.
It's covered.
It's covered, yeah, it's concealed. But the question is it a reasonable search in that circumstance? I'm inclined to think yes. I mean, if I'm authorized to take the gun, which I think you are, I mean, in that situation.
Yeah, in Arizona, we are authorized to
Mhm.
take the firearm during a traffic stop, and I always take them out of the holster just because I clear every firearm before giving it back to the driver.
Yeah, that was where I was going to go with that. Is when you want to hand it back to. We know we're probably going to be giving this gun back to him at the end of this traffic stop, and hand it back in a less functional manner. So it's so if he was to use it, which is probably remote in likelihood, but at least he has to manipulate it further to make it functional. I don't think it's I think it's reasonable, but no one. I don't think I've ever been asked that question before. So.
Let me ask you, Doug. What when you say you're authorized to disarm everybody in Arizona? When you say authorized, is that by policy, or are you aware of a state law that does this? Or
There is an actual statute for it. I don't remember off the top of my head, but I know there is a statute in state law for it.
hmm.
I wonder if it just codifies Terry. It's a statute that codifies Terry.
Yeah. Well, look, I don't know. Here's my thing. I think that I know that the Ninth Circuit is in your favor. The Ninth Circuit has a case that basically armed is dangerous.
Yeah.
But I like to play devil's advocate on this. Just because I like guns so much. If you stop me, Doug, and I'm an off-duty FBI agent, right? And I'm just going home, I'm just just traveling through whatever. Um, but I'm not drunk. I'm a 10 and 2, no troop. Yes, sir, no, sir. Are you gonna disarm me?
Um,
Off-duty FBI agent.
if you're off duty, I mean, I personally I would if there's no uniform that I can see, just because I'm going to confirm whether what you're saying is true or not,
Well, I
because
give
I
you my
have to
creds. I'm gonna give you my creds. I'm not gonna just say I'm off duty, right? I'm
okay.
like, here's my creds. The creds look legit, right?
Yeah, if you have credentials or you have a uniform, something like that, then I typically don't.
I just wish. Look, and by the way, a lot of officers do this. I just wish that they would have a reason for disarming somebody. I will tell you that again, the Ninth Circuit is anti-gun, but they also have, so they do have you're not gonna. But there is a case out of Indiana, and it has nothing to do with Arizona. But I'm just talking to you because this is a podcast, right? And I just like talking about these issues. But there was a case out of Indiana where the guy had a permit, and he had a gun underneath his seat. Okay, and and the guy says, "All right, I'm gonna disarm you," right? So he gets the guy out. He was gonna seize that gun underneath the seat, and he finds marijuana. And the court, at least went to the appellate court, maybe the Supreme Court, but the court said it was an unlawful search because the guy was doing everything, like he was allowed to do exactly what the law allowed him to do. And, it just like violated his Second Amendment rights in a sense. But I don't know. I just sometimes I get, when I see cops just as a matter of routine, just disarming everybody without a reason for some reason. But I also tell you, as a fellow trooper, that's the way we were trained in
Right.
Vegas. And I did kind of after a while, just personally me, I was like, I'm not doing that anymore, right? Handling all these firearms, it kind of disrespects the lawful gun owner. It's like it kind of like he's the guy. Here's my permit, sir. 10 and 2. I'm not going to disrespect you. And then we just disarm them. And I'm like, I don't disarm off-duty cops. So I don't know. That's just a good point. But can I share one more thing about the firearm? So I do agree with Zach. I do think that this is a search. Um, I guess if you have a state law that says you can disarm people, it also makes sense that disarming them also means unloading the weapon because you don't want to give back a loaded firearm, I guess, to that person you just took it from. Um,
Right.
but the one thing I am cautious of, and I think that the Ninth Circuit would agree with this, is that you shouldn't add an unreasonable amount of time to run that gun. Meaning, if I can count a decent amount of how much time would it take to add that search, that serial number check? Because that is not related to the traffic stop. You're not running a gun investigation. So if you're adding time to run that serial number, I think that's where the argument is. I think that's the main issue there.
Okay. That does make sense. I appreciate it.
Man, it's good stuff. See you, Troop. All right. Yeah. So Zach, you found it, right? So basically, that does give him the right. Again, I have case law that's in Doug's favor. Absolutely. That's probably also what they're training at DPS.
Oh, and just real, so Christopher posted that statute, and it's from Arizona. It says I was typing, but it says law enforcement officer contacts a person who's possessed of a firearm. The
Oh,
officer
there
may
it
take,
is.
yeah, but that presupposes an investigative stop. You can't,
Mm.
yeah, so you can't just do it on a voluntary contact. That so
Well,
I was
no,
checking
this was
that
a
real quick.
traffic stop, though. Doug said it was a
Yeah,
traffic
well,
stop.
yeah, but if you read the statute literally as the way Christopher has, it says if a law enforcement contacts a person, then he may take his firearm. Now, that presupposes that that contact has to be at least an investigative stop or a traffic stop, not a consensual encounter. I can't take someone's gun
No,
on a consensual encounter.
no, never, never, never,
Yeah.
never.
So I
Yeah,
just want
yeah,
to make sure that was clear.
yeah. Okay. Yeah. So anyway, but John is from Florida. He says does not fit Terry as no RS a precursor of criminal activity before the weapon issue. Yeah. So it looks like in Florida, you're not disarming the guy as a matter of routine. And I got to tell you, that seems like a Florida thing, right? Indiana is also pretty conservative. I can, that case. It's just that in Arizona, they're pretty pro gun there too. But the point is that I just like talking about it because if officers are called on it, I really wish they would have a reason, just more
Yeah,
than
yeah,
there's a gun in the car.
I agree 100% with what you said about, as a matter, I wouldn't do it. I would not do it as a matter of routine. And in some cases, it might actually escalate the encounter,
Yeah.
what it really needs to
Oh,
be.
let me tell you. Oh, let me tell you a story. I got the escalation story. So it actually happened. So I was teaching, I was teaching in Vegas, right? And
Hmm.
so there was this officer there, and he was like, "Oh my God, did you hear about what happened in?" I'm not going to name the city because it's a small city, and it'll call out this cop, right? But did you hear what happened? I'm like, "No, what happened?" So this cop stops this guy for speeding in from Utah, right? So he pulls him over, just speeding, daytime, and the guy's an off-duty cop, right, from Utah. He badges him. Sorry, sir, going a little hot, whatever it was. Well, nothing crazy, Zach, right? Not
Right,
triple digits, but going to
right,
Vegas, excited. And the cop was like, okay, so you have a weapon on you? Yes, sir. Got it right here, hands on the, and the cop was like, all right, well, I'm going to disarm you, for the traffic stop. And this Utah cop, this Ute, looked at this cop and says, "You're not disarming me." And
ouch.
the cop was like, "No, I'm going to disarm you." He's like, "No, you're not. I'm not doing anything dangerous to you. I'm going to be 10-2. My hands will always be visible, but you're not going to basically disrespect me by
Right,
disarming me when I'm an off-duty police officer and I've done nothing, you know."
right.
And so the cop then went to his sergeant and is like, "Look, I got a damn standoff over here. What am I gonna do?" And the sergeant's like, "Look, don't get into a use of force over this.
Yeah.
Let the guy go, right? And the question was in my class was like, hey, what do you think? Do you think that push comes to shove, he could have disarmed this guy? And I said, look, we're in the Ninth Circuit. Didn't you put that case up, the one
I
from?
did. Yeah.
I'm like,
Baker.
we're in the Ninth Circuit. Armed equals dangerous, but damn, that was good discretion not to have a damn use of force with a cop that
Yeah.
really you can't put your finger on anything dangerous
Yeah.
besides the gun.
The
It was really
sergeant being the voice of reason. Yes.
yeah,
Yes.
the voice. Yeah,
Gosh.
the
Wow.
sergeant is a voice of reason. Okay, so one more question. Okay, all right.
All right.
Since you asked, let's see what this one is. Hold on, hold on. Okay. All right. What does this one say? So this one is all right. I have a question. A guy allows a girl and a guy to live in an RV on the side of his residence for around 6 months.
Okay.
Not sure if they are paying the owner any rent or not. The owner calls the sheriff's office and says there are people in his RV that are using drugs and gave the deputies consent to go into the RV and search. Okay.
Okay.
Deputies entered the RV and found the couple in the act of using drugs. The male suspect admitted to being an addict and he was arrested. My question is, does the owner have the right to give consent to the RV if the people have been living there for 6 months? Have the people established residency? This case is out of Reno, Nevada.
Hmm.
So let's say, Zach, that we take everybody's word at this, that they actually the owner did allow these guys to live in the RV, okay,
Yeah.
and they've been there for 6 months. Is that their domicile constitutionally, or even NRS, which I have the answer.
Yeah. If he's that's where they're living today. Yeah. Yeah. Yes. That's
Yeah,
their house for Fourth Amendment purposes. Yes.
and it also under state law. Well, it's actually state case law. So I don't have the case name on top of my head because it's not that big of a case, but this is what they would call a tenancy at will. So in Nevada, a tenancy at will is when you allow somebody to live in your house. Here, it's an RV attached to the house, the same thing, basically for an indefinite amount of time. It's that whole classic, you let your ex-wife move back into the house to get back on her feet. You're trying to help her, ex-girlfriend, whatever it is, right? Cousin Eddie, he's not there for Christmas and leaving January 3rd. He's there, he's not there just for Christmas.
Yeah.
He's there indefinitely to get back on his feet or whatever. Nevada case law says it does not matter that he pays rent. What matters is, did he have the expectation that he would live there for an indefinite period of time, which is no set time to get out? If that's the case, then you have to have eviction orders to get him out. Now, I want you to talk about apparent authority under Illinois versus Rodriguez. Don't you think that's a factor here too?
Yeah. So we're only held accountable for what we know at the time or reasonably believe. And if as long as the person who's consenting, in this case, I guess the landowner is it's reasonable for the officer to believe this person has authority. It's his RV, it's his property.
Yeah,
His consent is still valid, even though he might not actually have authority. We later learn that he might not actually have
yeah.
authority.
Would you think, Zach, in this case, it probably is key that the cops did not know that he gave them permission to be there for 6 months? In other words, he calls up the police and like, yeah, these guys are doing drugs in my RV, and he
Yeah.
appears to be the homeowner, and it's maybe kind of random that these guys are doing drugs. Do you think that is a key ingredient here? Or if the cops knew that they were there for 6 months, would he have apparent authority at that point?
Yeah, no. If the officers knew that he had a parent authority, I'm sorry, knew that he was living there for 6 months, then that hurts our argument
Yeah.
that he has a parent authority.
Probably a roommate situation then, right?
Yeah, yes, but we can't stick our head in the sand and be willfully blind. I mean, we have to ask
I see. Yeah, I like
questions.
that. Right.
Yeah,
Just be reasonable, right?
yes,
Okay. All right. Do you want to answer a couple more questions?
sure. Remember, I think Ryan had one.
Oh, was Ryan?
Like, yeah,
All right. Where's
it was a
Ryan?
force one.
Okay. You use a force?
It was about the mental subject.
All right, Ryan. All right, Ryan. Hopefully you get that and you can answer the question live.
No worries. Are you there, sir?
Hey, buddy, how are you?
Doing well. Greetings from the great state of Idaho.
Oh my God, my future home. Where do you live in Idaho?
We were in southern Idaho, about halfway between Salt Lake and Boise off of Interstate 84.
Okay, I bought property in Sandpoint, outside of Sandpoint.
You are in God's country where the moose and
Oh,
elk
there's no doubt about it. I can't wait to move there.
so the sometimes it's a good idea if Fairy comes to pay us a visit, and our legislature, in their infinite wisdom, created this new statute that took effect as of October 1. And we're all kind of grappling on the law enforcement side as far as how we are going to deal with this. It is Idaho Code 562101, and it is a patient who is involuntary and suspected with a neurocognitive disorder. And this is for, we have our mental hold process. If you have someone who is gravely disabled, not taking
Mhm.
their meds, is a danger to themselves or others, believes that Donald Duck is in the room with them and they haven't, taken care of themselves, is walking to Washington, D.C. in the middle of the blizzard, wearing only shorts and a t-shirt type issue. So we have that, but this is now changing the landscape where this is geared towards people who may have issues like dementia, and they believe that they could be potentially dangerous to themselves or others. And the state saying that us as peace officers can now place someone who has dementia, as an example, on a hold and have them taken and transported to a medical facility, at which then it's up to medical staff that they can diagnose the person and then eventually release them to either a medical provider, courts, or family guardian.
What's the law
It's
again?
they're calling it the neurocognitive protective placement custody,
What's the
56,
number?
562101, neurocognitive.
Isn't there a dash somewhere in there? Or no?
Yeah,
Is it
sorry,
56 dash?
56-2101.
Okay.
And so, of course, from the perspective of constitutional policing, we're all sitting there going, this is kind of concerning. We could be putting someone into protective custody, seizing someone, uh, really without any sort of crime or intent or.
Well, but remember though, just one thing. Remember that cops have been doing this for generations, right? Over 200 years, people have been seized by the government when they are in a mental crisis, which is not a crime, right?
Sure.
So I wouldn't worry about, I wouldn't, I don't think that's the issue. I mean, I'm just saying like that's why we're here, right? I think the government, it's community caretaking, right? That's what the Constitution allows a seizure for community caretaking, which is, basically a compelling reason to help somebody out, right? But let's see what this thing says here. It says, it is the intent of the legislature that persons with neurocognitive disorder who are in acute crisis, okay, that's key, due to an unidentified underlying medical condition that can get the care they need and return home once the underlying medical condition is resolved. The legislature further intends that the state agencies and community partners will collaborate to provide the most dignified care for persons with a neurocognitive disorder. Well, that certainly is not enough to really get a sense of what this is about. Um, do you guys have this? When was this passed?
Uh,
2024.
yeah, so this is brand new legislation that just took effect as of October 1.
Hmm.
Even Lexipol doesn't have a policy yet to handle this.
Yeah.
Uh, we're all kind of trying to figure out what we can and can't do, um, and also making sure that we're not just, doing the habeas gravis.
So look, most meant, most, if not all, I guess, but um, civil commitments are based on a mental crisis, right? So this does expand it to be a medical condition, right?
Mhm.
Now dementia can be a mental crisis. It can be a mental issue, I think, in most, but this is like some medical condition. It can be physical, right?
Yeah. Mhm.
Um, and it has to be acute, which means, emergency, right? So, but this seems like almost like codifying something that's been going on anyway for a long time. I mean, EMS has been taking people to the hospital when they're suffering like an acute medical condition and people can't make um, a informed decision about their medical care. They take those guys to the emergency room for a doctor to check them out. Isn't that kind of similar here?
Uh, I would say so. The difference is they're more or less stating that this hold would be initiated by a police officer, by a peace officer of the state,
Right.
uh,
It's not EMS
or
doing it.
healthcare provider. So
Hmm.
it's more or less taking it from a medical standpoint, an EMS standpoint, a healthcare standpoint, and they're expanding it towards criminal justice through the courts and law enforcement.
Yeah. So let's kind of look at this real quick. Idaho's new crisis hold statute, like you said, takes effect October 1st. Allows hospitals to temporarily detain persons with neurocognitive disorder. Um, Mental versus crisis holds. The general rule, hospitals must have informed consent. That's a good point, right? From a competent patient, right, for medical care, um, or a surrogate. We know about that. There's generally no need for a mental or crisis hold. The hospital may provide care based, blah, blah. Mental holds. We know that. That's you guys been working with this for a while. That's a
Yes.
mental. Okay, we know that. That's gravely disabled. That's the same language in California law. A
And of
crisis
course,
hold.
the state of Idaho being such a vast state, depending on what judicial district you're in, gravely disabled is interpreted differently in the third judicial district than it is in the fifth judicial district through the courts. Some of it is also resource based. So, District 1 up in Sandpoint has a few more resources coming out of the Coeur d'Alene area than, i.e., the rural counties like Benoit or Boundary County to the north there, Bonners Ferry.
Yeah, I'm surprised. Look, I got to tell you, man. Look at this one. This one is abuse of substances. You know, a crack addict.
It's our daily business.
Man, that is interesting. Interesting. There's dementia, like you mentioned, right? And then Parkinson's disease. Interesting. So what's the standards? A person may be taken custody by a peace officer, right? And placed in custody, or the person may be detained in a hospital. Reason to believe that the person isn't and will injure themselves or others, likely to injure themselves. So what does that mean? Since a substantial risk, that's common language from crisis, mental crisis. Okay, well, it says right here, it says that serious physical harm will be inflicted by the person upon their own person, as evidenced by threats of suicide or threats to elicit serious physical harm on themselves. A substantial risk that serious physical harm will be inflicted by the person upon another. The person lacks insight into the need for treatment, is unable or unwilling to comply with treatment based on a person's medical history, clinical observation. This is the problem. This is probably the one that's causing the most heartburn right here. They're not making the medical decisions that we would make, right? That's kind of concerning, right? Would you agree with that?
Yeah, and of course, my training and experience is limited to law enforcement, not to the medical side. So I can
Now,
do the basic CPR first aid, but
barely, yeah. Now,
yeah,
does this concern you? This substantial risk business? I mean, isn't that very similar language from mental crisis?
it's very similar already to our mental hold statute with the 66 326.
I mean, I don't mind this part because that's kind of like, it's not from the mental crisis, from the physical, but I mean, suicide and harming other people, I think we can agree on that.
Oh yeah,
It's probably this part that's causing some consternation. I mean, what do you think about this, Zach? It puts the cop in a very tough situation, huh?
Yeah, I mean I was reading if you reading further down, I guess the purpose, I guess there was a gap in the old mental hold statute specifically excluded people with neurological disorders. Now I guess they've decided to include them, but that seems like much more of a medical diagnosis. How hard is it to get like an EMT that was seen on a situation like this? Maybe, you find somebody wandering down the street. Can you just call medics and have them,
uh,
help with the
depending
assessment?
on depending on your county. The county that we are in does not have paramedics. They are your basic first responder, EMT basic and advanced level, but we do not have paramedic level service in our county.
Okay.
Hmm.
Um,
Man.
Yeah, I'm not sure if you folks have seen anything like this in any other state or if anyone in the audience has experienced anything like this in any other state.
Here, we're gonna get Mike on the we're gonna get Mike on the line. Mike can help us here because Mike is a trained paramedic, and I we can use his advice here. Hold on. And he's in Idaho. Hey, Mike.
What's up?
Hey, help us out here, man. How should we look at this thing for dumb cops like me to use this if I'm in the field?
Well, this thing looks like a lot to read and digest. It's not it doesn't look like some quick thing.
Yeah,
But it looks like it's what I was catching is it looks like something that more of a tool for the doctors to use at the hospital. But they're going to pull the cops into it because they want the cops to enforce this order.
right. Are you a par I might have misread that. Are you a paramedic or no?
I am a paramedic,
But
and
not in Idaho. You're where are you at?
no, I'm dying to move to Idaho.
Yeah,
Somebody,
you
I want to go to Idaho and claim asylum from California.
yeah. Just make sure if they hear that you're from California and you ever remotely vote like a Californian,
No, 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 no.
they will kill you, man.
No. I'm from Montana. I'm just in California right now.
Well, they say that 70% of Californians moving to Idaho actually vote like they're supposed to. So that's good.
Over your feet.
Yeah. So look, this is, I mean, you guys deal with this stuff all the time, with these people who are, they should get, whether or not they have the capacity to make medical decisions, right? It's
Yeah.
just, it's just like I really see where Ryan's coming from here. Like it really should be like I would want to push this onto you. You make this decision. I don't want to make this decision.
It seems like it's like a discretionary kind of thing, but like I think about my grandpa in Virginia.
Hmm.
My grandpa in Virginia is a FFL, and he started hallucinating and thinking that the trash can was coming after him and going to kill him.
Yeah.
And
Yeah.
I had this conversation with my mom, like, well, we're all like very pro Second Amendment, but it's time to take his guns, and it's
Sure.
got to be, if the government's not going to do it, like we as a family need to step up and intervene. And so it just seems like they're just glancing at this legislation. It seems like they're kind of making it a more official process, but it seems like this requires discretion, not.
You know what? One thing, what do you think about Mike and Ryan? What do you guys think about calling a hospital and going over what you see and observing with the doctor and helping and having them maybe help you make this decision?
Well, I saw in the one thing I did see as it's coming through is it doesn't only give the cops this authority, it also gives physicians and nurse practitioners
Yeah.
same authority. So you could maybe kind of kick the ball over to them and go,
I've
hey,
seen that happen with mental crisis holds. Ryan, even though you don't have a paramedic in your county, what about calling the hospital and running a scenario by them? Do you think that would help?
That's a really good suggestion. I think that may be the direction that we'll have to go. Uh,
Yeah.
is phone a friend, find someone smarter than us. When it comes to the medical stuff, that's not what our training is based off of. But definitely, we can phone that friend and get a hold of a local physician at the hospital and say, hey, this is what we have, this is what we're seeing. What do you think?
Yeah.
And it'll be, of course, partly up to that physician as far as whether they say, yeah, bring him in, or they're going to want to kick the can down the road.
Yeah. I will tell you some good news though. Look, at the end of the day, you can comply with the statute in good faith. You know what I'm saying? Like it was passed by your legislature. It is presumptively lawful. It is a new direction for Idaho, and Idaho is very concerned with personal liberties and so forth, which one of the reasons I want to move there. But you are, you like what I mean by that is if you have a person who, is exhibiting these signs of self-harm or harm to others and, has this neurological issue, detain them, keep the peace, help them from themselves, and then just I would want to talk to a doctor. Now I will tell you though, Ryan, 99% of the doctors that you talk to are going to tell you what, bring their ass in. You know what I'm saying? They do not like. I rarely do I see a doctor saying, "Nah, they're okay," because they don't want that liability. You know what I mean? But but when you put in your report that I spoke to Dr. Jones and they told me that they want to see the patient based on what I told them, it does help alleviate your concern about, respecting people's liberties, but also giving the help that they should probably get, right? And not be a harm to themselves and walk into the middle of the street and kill themselves, right? So, Zach and I are no means experts on this law. I've never even heard of this law. I can definitely understand the concerns, but I think that's what we agree on. Mike, you think that's good advice too? Just call the doctor if they can.
Yeah, I mean, I think it's a more reasonable approach. And this law looks like it's a lot to digest.
Yeah.
So
Yeah, it's a lot for a cop, that's not medically trained.
this
Because
is
I see this stuff and I'm like, I gloss over it, man. My eyes go in the back of my head.
yeah. I think check with the doctor and let them make the call because they
Yeah.
have authority to make that call under this law.
Yeah, look, and pass it on to them. So look, I think we made a little headway here. I definitely am no expert by any means, and obviously I can't give you legal advice because I'm not your attorney. But that's what I would do. So thank you for this conversation. And Mark online is saying articulate. I agree, but also I think we should also agree that there are going to be some times when people fall under this law and like, yeah, absolutely, this guy needs to go to the hospital. He needs help. You know what I mean? Versus the family saying he has dementia, but yet he's talking to you, and he may not be sharp as Zach, but he is still functioning, and that guy doesn't go to the hospital without his consent, right? I think we can agree on that.
Gents, thank you so much for the advice. Appreciate the insight.
Yeah, it was great conversation, and thank you for bringing this to us too. It's new for us, and it's good for conversation. Thanks, Mike, for jumping on, my friend, and
Sure.
get out of California.
I got 8 years left.
Oh, can I ask you where you work? You just count where?
Lancaster.
Okay. Well, I will tell you though, Idaho is chock full of retired California cops because you bastards, and I hate you for this, come with your amazing retirement checks, 90%, up to 90%, and you move to Idaho and you buy out the place, and poor people like me can't buy a decent 6,000 square foot home anymore.
But the California cops will not change the politics of Idaho, I promise.
Oh, they will not. No, they're actually probably more.
Yes.
No, they're more red, man.
Yes.
No, you guys have seen it firsthand, brother. All right. Thank you. See you, Mike. All right. So look, this was a great conversation. Zach, I appreciate. Are you at home? Where are you at, Zach?
I'm at home to this week.
Okay. I got an early flight. We're prepping for ICP this week. We're gonna send a lot of videos and pictures and so forth. So thanks, guys, for joining us, and I appreciate you, Zach. Thank you.
Thanks a lot. Have a safe trip.
All right, guys. This is it. So thank you, guys. Have a good night.